bienvenida nuevamente y agradeciendo nuevamente su presencia a la doctora Alexa Koening, directora del Centro de Derechos Humanos y profesora de la Universidad de Berkeley. Ella es directora ejecutiva del Centro de Derechos Humanos y profesora de Derechos Humanos y Derecho Penal Internacional de la Universidad de Berkeley, priorizando el impacto de las tecnologías emergentes en el ámbito de los derechos humanos. Cuenta con un PhD y un MA en Jurisprudencia y Política por la Universidad de Berkeley. Es cofundadora del Laboratorio de Investigación de Derechos Humanos, así como miembro de la Junta Consultiva de Tecnología de la Oficina de la Fiscalía en la Corte Penal Internacional. Forma parte del grupo de trabajo de inteligencia artificial de la Universidad de California y entre sus publicaciones relevantes para este tema destacan Hiding in Plain Sight, Using Online Open Source Information to Investigate Sexual Violence and Gender Bias Crimes, Technologies of Human Rights Representation, Strengthening Atrocities Cases with Digital Open Source Investigation, Open Source Investigation Information, Blind Spot y Human Rights, Psychology and Artificial Intelligence. Los leo de manera muy rápida, pero bueno, les invito también, por favor, a que vean esta investigación, estas distintas fuentes que de verdad son valiosísimas. Y bueno, sin más que decir, le doy la palabra hasta por 30 minutos, creo que sería a la profesora Alexa Koenig. Y los que están aquí en Zoom pueden ver la interpretación dándole clic al mundito para ponerle español o inglés según su preferencia. Muchas gracias.
Thank you for this kind introduction, and thank you also to the organizers and my co-panelists for the conversation that we're having today. I'm very honored to have a chance to introduce to everyone. Let's see, I think that was unmuted. So I'm very honored to have the opportunity to introduce to everyone a document that several of us at the University of California, Berkeley worked on with the United Nations Human Rights Office to pull together a set of international guidelines to help improve the admissibility, reliability, and probative value of social media content and other information posted to the internet and publicly accessible to strengthen cases of human rights, humanitarian law, and international criminal law. Even though this document is very much aimed at practitioners of human rights, it is the basic principles within the document itself are broadly applicable to all of those who are hoping to use what's known as online open source information in their case building and in building the evidentiary foundations of litigation. I'm going to go ahead and share my screen and hopefully cross my fingers that this presentation works. And go ahead and present. So as I mentioned, I will be speaking a bit today about the Berkley Protocol on Digital Open Source Investigations. This document was released in its preliminary form in English in December 2020. We are optimistic that the document will be released in all of the languages of the United Nations sometime soon, ideally by the end of this summer, but we will be happy to keep you apprised of the progress of those various forms. What I'm going to cover in the next 20 minutes is an introduction to the protocol and the guidelines that it helps to set, talk a little bit about the legal considerations raised by social media information, the ethics and security considerations that are particularly heightened when working in an online format, talk through how many of the methodologies present in the protocol can be worked into pre-investigation steps, and also how this can be incorporated into a legal investigation process. Much of the work that we do at Berkeley started in the context of looking at how much information was increasingly being posted to social media and other sites online that potentially had probative value for war crimes and other international cases. Syria has been commonly referenced to as the first YouTube war because of the huge volume of information that has been posted by people most impacted by atrocities there to different places on the internet, and especially in video format to the internet. As you may all already know, more than 500 hours of video are currently being posted to YouTube alone every minute. More than 6,000 tweets are being generated every second. One of the questions that have been asked by our team and by others with whom we work is how can we harness the extraordinary amount of information now available online and use that to triangulate and corroborate the information that's coming from more traditional forms of evidence, like the testimonial evidence given by witnesses and bystanders to atrocities, the physical documents, the physical items like the weapons of war, et cetera, that may be collected. And then, of course, also the more traditional forms of documentation like contracts, written orders, et cetera. We have, over the last decade, witnessed the increasing use in international trials in particular, but also in different jurisdictions nationally, how social media content can be helpful for opening cases and then eventually actually bringing those cases through to completion. One example in the international context has been a case known as the Al-Warfali case that came out of Libya and was recently in the International Criminal Court. This was a milestone in international criminal justice because it was the first time that 7 videos posted to Facebook and other places online became the basis for an international warrant of arrest. Where even a decade ago in international tribunals, it was believed that social media content could only ever be offered as lead information. So basically information that would get you to witnesses who may have been present at the scene of a crime, or to help you understand the physical and documentary evidence that might be available to strengthen your cases. Now I think there is an increased understanding that this can actually be primary evidence in courts of law. Of course, different jurisdictions are at different stages of actually incorporating this information into their case building. So what is digital open source information? Essentially, as it's defined in the protocol, it is publicly available information that any member of the public can obtain through observation. So meaning you put into some kind of search browser the terms of the item that you're hoping to find, and you see what ultimately emerges on your computer. By request, or by purchase. And we included the latter, meaning some form of reasonable purchase that is broadly accessible, because so many people now receive their information online through news and other sites where you may have to pay a minimum subscription fee or other small amount of money to actually access that document. But it is so broadly still accessible that we figured that it would fall within this public accessibility definition. This can include things like websites and blogs, forums and chat rooms, social media platforms, but also streaming like we have going on today, and also data sets, government files, et cetera, that are publicly accessible. What it does not include is any information where you need some kind of special qualifications to access that information. For example, being law enforcement and having to issue a subpoena for the information. It also does not include information that you need some illegal means to access. So for example, illegal hacking to break into some kind of system to access the information would not qualify as open source information. That information is ultimately helpful for 3 different buckets of purposes as part of justice and accountability processes. First, as intelligence. So as background information that can help with decision-making around the who, what, when, where, why, and how of a particular event. It can also be used as lead information that will lead you to primary evidence, like the testimonies of witnesses and survivors, or the documents that may be relevant to your case. And finally, as primary information, as mentioned in the Warfali example, but is much more broadly applicable. One other point that we really like to underscore, because I think it really does speak to the need for training about how to systematically access information from online public spaces, is how what a small percentage of the information that we find online is actually accessible when we go to Google or to some other search browser and we plug in terms. That is known as the surface web. What ultimately emerges, it's the information that's been graphed by these companies and that you can easily get by just putting in search terms. The vast majority of the internet, though, is what is known as the deep web. This is where information resides in publicly accessible forms online, but you need to know how specifically to access it through the place that is holding it online. It is not indexed to one of the search parties. The third is the dark web, and that is where you need some kind of special software, typically known as the Tor browser or the Onion router, to actually get into that portion of the internet. And this is where we will often find information related to trafficking and other illegal activities that people are not posting to the deep or to the surface web. The foundation of the protocol are a series of principles that were developed between the UN Office of the High Commissioner for Human Rights, the University of California, Berkeley team, but also with consultation from more than 150 experts working on digital open source information around the world. Also a series of workshops that were hosted globally to try to work through very either less settled areas of law or to discuss emerging areas of legal practice where there is no clear consensus. We've bucketed them into professional principles. So what are the principles by which we should think about our own ability to conduct this kind of investigation in online spaces and bring that information into legal process? The second are methodological principles that are predominantly focused on how do we increase the quality, the efficacy, and the efficiency of the work that we're doing and maximize the security, since working in online environments does raise new security challenges, not only for lawyers and legal investigators, but of course those people who may be depicted or discussed in the content that we're gathering, as well as people who may be tangential to the case itself. And then finally, ethical principles that are very tightly tied to human rights conceptions of privacy and notions of how we present this information in a way that preserves the dignity of all involved, but also helps get us clearer about the facts underlying a case. Some of the legal considerations that are particularly acute when working with this kind of information for case building purposes is, for example, the right to privacy. Since we work predominantly at our center in international legal contexts, I'll give an example from the International Criminal Court. At the International Criminal Court, there's a very low threshold for the admissibility of evidence. However, the one potential bar on admissibility is the violation of human rights. One human right that is particularly salient in online contexts is the right to privacy, because privacy is so easily breached when we are pulling vast amounts of information from people's social media profiles or from the profiles of their family members, etc. And so an unknown area or an unknown question at this point is whether the violation of privacy that may come with observing large quantities of information about individuals on the internet, whether that could be considered a human rights violation that would in some ways really harm the admissibility of that information for legal purposes. Data protection laws are shifting quite quickly in many jurisdictions around the world. And this is such an area of rapid transformation that we're finding this is one of the areas where open source investigators are really grappling to understand the legal limitations on what they're able to do. It is very tempting when you go to YouTube or Twitter to scrape large quantities of content that are potentially relevant to your case. However, that can, depending on how you hold and store and process that information, you could be in violation of data protection laws if you are not aware of the regulations that relate to your practice. Terms of service violations are less of a legal concern and more of a contractual issue. So many of the social media platforms have limitations on what you are allowed to do in those online spaces, including the quantities of information that you can siphon from their platforms. What has repeatedly been found in many jurisdictions around the world is that that will not be seen as a legal violation if you violate the terms of service. However, there is always the possibility of the platform eventually removing your ability to access their platform because of those violations. And of course, this can emerge as an ethical issue as well. Finally, intellectual property is another issue that has repeatedly emerged, particularly in the publication of information sourced from social media. And then defamation. We've seen several cases emerge where information is pulled from an online social media platform, and the people who are depicted in that information have argued that the use of that information is defamatory. So how this works into the legal process, there are special steps that we would recommend any legal investigator or lawyer take prior to commencing one of these online open source investigations. The first is to do a digital risk assessment. How does the searching of these online spaces potentially change the risks to your team, to the people, to your client, to the people who may be depicted or in some way implicated by the work? As many of you probably know, when you visit a website, you are not necessarily anonymous. Certainly the equipment you're using to access that website is often logged by the owners or the holders of that website. And one of the things that many online open source investigations teams have found is that if there are too many investigators all visiting a similar site at a similar time, that can definitely be a tip off to the people that you are investigating that there is some kind of investigation going on. So that risk assessment needs to be done for all of the parties who may be implicated. The second pre-investigative step that we strongly recommend in the protocol is to do what's called a digital landscape assessment. That means to systematically and thoroughly assess where people may be communicating in online spaces, where there may be relevant information that has probative value to your case online. It is very easy as we become more and more familiar with certain kinds of sites like Twitter or YouTube or Facebook to rely on those overly for the kinds of information we collect. But of course, there are very different regional patterns in what online platforms people are using. This also changes quite a bit based on age, gender, geography, etc. So really taking a look at who is accessing these spaces is quite critical. One of our areas of research now is looking at the potential ability of using online open source investigations to investigate sexual and gender-based violence crimes, which are some of the hardest crimes to prosecute. There has been an assumption among some online investigators that that information is not available. What we're finding is that it is available, but oftentimes people aren't understanding where to look, or the gendered pattern of online uses of technology that really can shift how a legal investigator may approach this material. We're also finding it's very important when mining these online sources for evidence or information to have developed a lexicon that's relevant to the people and to the issues that you're investigating. Particularly with stigmatized crimes, we find that a lot of people speak in code. One classic example is an issue here in the United States that we've investigated is neo-Nazi activity. We have a colleague, Paul Myers, who has written quite a bit about how no one signals that they are a member of the neo-Nazi party or somehow affiliated when they're in online spaces, but they may use the code 1488 to signal to each other their affiliation. 14 being significant for a 14-word speech given by Hitler, and 88, the part of being representative of the 8th letter of the alphabet, H, so for Heil Hitler. So those kinds of coded terminologies, to get a key being a common term in trafficking cases for actually trafficking in women. Those are the kinds of things that you will need to have when doing these very text-based investigations. Ultimately, once these investigations, this digital landscape assessment is done, this feeds into an online investigation plan that ultimately feeds into the full arc of a traditional investigation cycle. Of course, preservation is a really critical part of this. Information online is ephemeral, often taken down by the platforms, particularly if it's graphic or otherwise violates their terms of service. And the verification process is also very important because we do know that digital content can very easily be manipulated. We, of course, have issues of deep fakes where information is generated by algorithm. How do we know that this digital content depicts what it claims to depict about what has taken place in the world? So I will skip over this because we've really covered it. In the digital risk assessment, we want to think about digital harms that may accrue. So for example, someone taking over your computer, malware potentially being installed depending on the sites that you access, physical harm to yourself and all implicated, but also psychosocial harm. One thing that we found is that when you're investigating criminal activity online, you may be bombarded with some of the worst things that human beings can do to each other at very large volumes, particularly if an atrocity has taken place and been captured by hundreds, if not thousands of people. So having in place protocols for the psychosocial well-being of your team and of others who may be exposed to this very toxic material can be quite critical for sustainability. Reputational harm. So we certainly know of when investigating in online spaces when this is tipped off or when people feel threatened by the investigation. As in any investigation, protecting your own reputation and having a plan to protect that is quite important. And of course, both financial and legal harm. When we talk about security, we do think about these three buckets of physical, digital, and psychosocial, and those are touched on in the protocol, but we are always happy to share some of the resources that we have provided at our center. And then in terms of the digital landscape assessment, I covered most of this, but again, these are some of the buckets of material that may be helpful to grab. In terms of geographic scope, really understanding also the laws and regulations related to the criminal activity you're investigating can be quite critical. So for example, in areas where certain kinds of, say, sexual activity is prohibited, it will be very difficult for people to speak about that openly online. So again, developing these lexicons of coded terminology can be especially helpful, or understanding the symbols and the memes that have evolved around a particular phenomenon. In terms of your online investigation plan, really understanding the research questions that an online investigation can help with is quite important. Also coming up with the planned activities and how those will be distributed across a team. Mapping the actors in the space who may have an online footprint. And then having these security and strategies in place can help to facilitate information collection. In terms of the verification, I think one of the big risks we're often hearing about is what is the reliability and the probative value of the actual content itself, knowing how easily people can imitate each other in online places. We have certainly had cases where we've seen that happen before. There was recently a deep fakes example where someone had an audio deep fake where a gentleman who worked in a financial institution received a call from a person that was claiming to be his boss. It was actually an AI-based process that had imitated the boss's voice and was asking for the transfer of several $100,000 to a different bank account. The particular financial institution employee did transfer the funds, thinking this was his boss, but then later got suspicious when there was a second call and actually had his boss on the telephone when the AI voice was making a second demand for the transfer of additional funds. And this was a case that happened in the last couple of years, but we're beginning to see some of these issues around manipulation and fake generation of information. So as a result, one of the things that we found about ensuring the reliability of this content is the importance of going through a three-step process, looking at the technical information that may be attached to the video or the photograph that you collect online. Is there still metadata? So information about the exact item that collected it, the date, the location, etc. That can be a corroborating point or disproving point to what you've been told about that item. EXIF or metadata can be manipulated. So it's important to not use that as the full truth of the veracity of that piece of information, but to use it as one clue that then gets further corroborated. The second is source analysis. So what was the source of this information? If it's a person that's on Twitter, even looking at if they're claiming to be posting something about, say, an atrocity in Syria, have they consistently been posting from Syria, or were they claiming to be in a very different part of the world even months previous? Little checks like that, or checking across their social media profiles. So if you find this on Twitter, do they also have a profile on Facebook or elsewhere on the internet? And is that consistent as to who this person is and who they claim to be? And then the third is content analysis. So looking at the actual interior of a visual image, like a photograph or a video, and is the information there consistent with what can be concluded about that location in the world? A lot of people are now using satellite imagery and comparing the satellite image of a particular location to the actual image in a photograph or a video or drone streaming footage to see if those are consistent and if you can actually map different geographic markers across those bits of information. So finally, on documentation, documentation is one of the most important parts of working with this kind of information, thinking through and really notating who's done what, how they did it, and how credible you believe this information to be. Finally, I want to give the last word to the High Commissioner for Human Rights. When we launched the advanced version of the protocol, High Commissioner Michelle Bachelet said that the protocol is ultimately about protecting human rights and advancing justice. In this regard, I welcome in particular its principles of humility, inclusivity, and dignity. We are now taking the necessary steps to ensure implementation of the protocol in our own investigations and those we support. I encourage others to do the same in their own areas of work. I hope you found this helpful. And as I said, this will be released in all of the languages of the United Nations, hopefully quite soon, including in Spanish. And we look forward at UC Berkeley to supporting if anyone would like to dig further into the foundation that it lays. Thank you.
Muchísimas gracias, profesora Alexa, pues por mostrarnos cómo la información en línea tiene todas estas implicaciones y bueno, como, claro, todos, bueno, sobre las personas que se dedican a hacer investigación en línea, si no conocen este tipo de reglas, este tipo de protocolos que hacen ver claramente que la información puede ser manipulada, puede ser generada y puede trastocar derechos humanos. Entonces, bueno, pues muchas gracias por presentarnos este gran protocolo que nos da los principios legales, metodológicos y las competencias profesionales que son indispensables para analizar, para verificar y presentar esta información como evidencia en un proceso. Toda esta perspectiva internacional de cómo la información se utiliza en línea y cómo puede presentarse como pruebas tal cual. Llegamos al punto de las preguntas. Tenemos varias preguntas aquí planteadas. Pasamos a hacer las preguntas que han mencionado para la profesora Alexa. Hay dos preguntas generales. En su experiencia con personas que realizan este tipo de investigación descentralizada de open source, ¿qué tanto se utiliza para casos nacionales en comparación con su uso para casos internacionales? Y sobre todo, ¿qué tanto la investigación de open source que de hecho se realiza en el mundo, realmente sigue los principios y regulación que nos ha comentado? Es decir, ¿en qué grado las personas que investigan y jueces o juezas que evalúan la evidencia están capacitados en los temas que nos está comentando o qué tanto haría falta? Y la segunda pregunta es, dentro de un juicio en materia penal, ¿qué validez se le da a una prueba de reconocimiento facial para procesar y sentenciar a una persona probable responsable? Y en su caso, si se hace, si tiene algún ejemplo o cómo en general se han combatido los sesgos que se generan con el uso de esta tecnología en caso de que sea considerada dentro de un proceso judicial.
Thank you for the questions. With regards to the first question on open source information, what we have found is that the use of such information in court processes differs radically depending on the jurisdiction that you're in. Some courts are much more equipped to handle digital information in non-traditional ways. So classically, when you introduced a video, for example, in international criminal cases, you would submit with it a PDF or similar type document that really lay out the information about the digital piece of information. Increasingly, though, we're seeing different kinds of platforms being developed to help the judges and juries better understand the physical layout of areas where different crimes have taken place. That is really a compilation that's built off of the visual information collected from social media. We are finding that most judges and lawyers are not trained in these methodologies. And so one of the reasons that we did work on the protocol with the United Nations was to help bring greater awareness to the fact that different jurisdictions are beginning to see more and more social media content introduced into court. And we wanted to give people a basis by which to not only ensure the accuracy of that information and to better probe its value for court purposes, but also to challenge it. And so one of the pieces that I'm working on right now with a colleague, Lindsay Freeman, is an overview of what we would advise defense attorneys, for example, how we would suggest that they begin to really probe the quality of the open source investigation and to help judges better understand what questions to be asking of the investigators who introduce this in court. There was recently a mock trial on the potential admissibility of a video related to an alleged international crime in Syria. It was fascinating to see that the Berkley Protocol was already being used as a basis for assessing the quality of the underlying investigation. But we did find that the judges and lawyers sometimes struggled with asking what we would consider very important questions about the collection process and also the verification process. And so that is something that we're going to be hopefully issuing more guidance on soon. The other thing that needs to happen is trainings. And so we are beginning to have conversation with places that do judicial trainings in different parts of the world to ideally walk people through the protocol and do some basic training on how you do collect this kind of information to some sort of forensic standard. The standards are changing rapidly. So whereas it used to be enough in most jurisdictions to do a screenshot of information that you found on social media, increasingly we're finding that judges do not consider that acceptable, and they want a full forensic capture of not only the video or photograph that you found on social media, but the surrounding comments comments and context. They want a time and date stamp. Ideally, they would have it sent directly from the social media company themselves into court to preserve chain of custody. But when that item has disappeared from those platforms and investigators are the ones who've collected it, there are emerging norms that I think have changed even in the last year that lawyers and judges need to stay on top of. In terms of facial recognition technology, as is suggested by the question, yes, there are very broad known biases. We know that many of the algorithms that are used in facial recognition technology are very biased in terms of gender, but especially in terms of color, because many of the faces on which the underlying algorithms are trained in order to hone the identification process have relied on lighter skinned faces. And so we have found I think a lot of researchers have found a fairly large fail rate in the ability to detect imagery. There was recently a situation where a gentleman in the United States in Michigan was misidentified by facial recognition technology by the police. Thankfully, he did end up going to jail for quite some time, and it was only later when the underlying algorithm was probed that this was discovered. And so we're beginning to see these emerging cases of people who are actually imprisoned and challenging their convictions on the basis, or their imprisonment on the basis of the flawed technology. I think what we're going to increasingly see is two different responses, certainly legal solutions and technical solutions. So in terms of legal solutions, we're certainly seeing a wave globally of different new legislation being established in national jurisdictions to try and limit police uses of facial technology to identify perpetrators. Where I think it can be really helpful, and it's relevant to open source investigation, is that it can be helpful for beginning to narrow down the extraordinary volume of information online to try and find videos and photographs that may be relevant to a case. But I think it should never be used as determinative in itself. It should be used as a lead to further, to try and make a more manageable selection of information online. The second are the technical solutions. So I think just this past week, there were a number of announcements of different companies who are trying now to feed bad information into these algorithms in order to train the algorithm what it's doing wrong, and to basically try and minimize the use of algorithms to generate hate speech by teaching it what hate speech is, minimize the misuse of or the misrecognition of people's faces by increasingly refining the ways that it analyzes this visual data. So maybe I'll leave it at that.
Muchísimas gracias, profesora Alexa. Y bueno, sobre todo por esta perspectiva que creo que se ha repetido constantemente en el seminario de no solamente es una cuestión legal, que es lo que nos ocupa más en este módulo específico, sino también tecnológica, ¿no? Es entender cómo funciona y un poco lo que nos comenta la profesora es, a veces tienes que explicar cómo viene la cadena de custodia de una prueba específica en un PDF, o tienes que explicar la tecnología por sí misma para que pueda tener un valor probatorio específico. Y bueno, muchas gracias.